Criminal Case Procedures by Andie, Emily, and Kimberly. First off, we have the arrest. It's when a police officer may arrest someone if he A, personally observes a crime, 2, has a probable cause to arrest that person, 3, an arrest warrant has been issued. The police officer must protect citizens' constitutional rights, and if these rights are violated, the arrest may be considered unlawful. The police must be consistent about reading Miranda rights. Next up, we have booking, an administrative process where the police collect personal information and organize evidence and then place the subject in a holding cell. Arraignment. The person charged with a crime is called before a criminal court judge who reads the charges against the person, asks the defendant if he/she has an attorney or needs the assistance of a court-appointed attorney, asks the defendant if he or she pleads guilty or not guilty or no contest. Okay. Decides whether to alter the bail amount, announces dates or future proceedings in the case, and finally gives the defendant police reports and any other documents. All right, next we have preliminary hearing, usually held soon after the arraignment, best described as trial before the trial. A judge decides if there is enough evidence to have a trial in the first place. Next up, we have pretrial negotiations, or P-bargaining. The defendant agrees to plead guilty to one or more charges in exchange for a more lenient sentence. Many criminal cases are resolved this way before a trial. Next up, we have the trial. First, you have to choose a jury of an unobjective person. So no strong opinions about the case would be okay. So they'd be like, no, you can't be on the jury because you're strongly feeling about this way. And then next, you have, stop, Kim, 2 opening statements, one from the prosecutor, from the United States or the state or whatever, and then the second one from the defense or the defendant's person. Next, we have the witness testimony and cross-examination. Witness swore he has to tell the truth, and after that, you have the closing arguments that summed up the case. They're like, I'm right because blah blah blah, and they're like, no, I'm right because blah blah blah, and then that's it. And then they have a jury instruction, so the judge gives the jury a set of legal standards to decide guilty or not guilty. So they go into a room and they're like, let's figure this out, and that's called the jury deliberation. And afterwards they come up with a verdict, and it has to be a unanimous decision by the jury about the case. Now this verdict, it says the jury's decision in a trial is what the verdict is. So sentencing follows, which dictates how long a person found guilty will serve the proper punishment. Like our verdict is, we were found guilty for 6 counts of bad puns. But then comes a possible, not necessarily, an appeal, which we're appealing that the verdict is wrong, because an appeal is asking a higher court to review certain aspects of the case for legal error as to either the conviction itself or the sentence imposed. So that's all we have today, folks. Make sure to tune in next time we do this. It was, yeah, I think that's it. Yeah, that's it. And then we'll talk to you next time. Bye.